right, good morning, everybody. My name is Dr. Daniel Hackman. I'm the medical director at the Kentucky Correctional Psychiatric Center in LaGrange, Kentucky. It is my honor and privilege to introduce today's Grand Round speaker, Dr. Alexis Glomski. Dr. Glomski graduated with a Bachelor of Science in Neuroscience and a minor in Business from the University of St. Thomas in St. Paul, Minnesota. She completed her Doctor of Osteopathic Medicine from the West Virginia School of Osteopathic Medicine in Lewisburg, West Virginia. She is currently a fourth-year general psychiatry resident at University of Louisville. She's won various honors and awards, including in 2021, the Consult Liaison Psychiatry Resident Award. She has a long history of being an educator. She served as a tutor for 8 years for various middle, elementary, and high school students in different subjects. I've gotten to know Dr. Glomski because she expressed an interest in forensic psychiatry early on in her residency. And so she came out to KCPC during her second year or beginning of her third year, and to kind of see what we do. And then from there, she's continued to express an interest in forensic psychiatry. So we began doing some research in competency to stand trial systems, and recently presented at a forensic psychiatry conference just this past weekend. Dr. Glomski will be finishing up residency next summer, and will be attending the Case Western Reserve University Forensic Psychiatry Fellowship, which is one of the most prestigious and hard to get into fellowships in forensic psychiatry in the country. And so with that, I'm very excited to hear Dr. Glomski present on competency to stand trial systems.
All right, thank you, Dr. Hackman, for that introduction. So let me share my screen. Okay, so starting off, here's just the CME information for those of you that need it. All right, can you guys see my presentation now?
Yes.
Okay. All right, so today I'm going to talk to you guys about the competency systems in the US, and specifically we'll take a look at the rights of the mentally ill within this system and how we are or are not protecting their rights. I do not have any disclosures. Today our objectives are going to be to define competency to stand trial, review the history of the CST, which stands for competency to stand trial, and relevant cases related to it, understand current issues within the CST systems, begin to understand state differences for the CST evaluation and restoration services, and discuss some possible approaches to improve the CST system. So starting off, what is competency? It's the quality or condition of being legally qualified to perform an act and or make decisions. So that seems pretty vague. If you go into the details, it's task specific. So it applies to one specific task. It doesn't mean because you're competent to do one thing that you're competent to do everything. It's moment specific, so it's an assessment at that moment in time. Someone may be competent to do something now, and in 6 months, they may not be competent to do that same thing. A psychiatric diagnosis does not define whether or not someone is competent. And we operate under this presumption of competence. So essentially, we assume people are competent and have to prove that they are incompetent, rather than the opposite, where we would have to prove that they are competent. And the threshold for determining incompetency can vary depending on the task at hand. So it can depend on how complicated the task is, how much reasoning skills and abilities they need to have to be able to accomplish that task. There's several different types of competencies. Today, we're going to specifically focus on competency to stand trial, which is one of the criminal competencies. And here are some of them. This isn't a complete exhaustive list of the criminal competencies, but some of them are stand trial, to plead guilty, to waive counsel, to represent themselves, competency for execution, and to waive Miranda rights. So like I said, today we're going to talk about competency to stand trial specifically. This is the most frequently raised issue among the criminal competencies that there are, and it can be defined as having a sufficient present ability to consult with his lawyer or her lawyer with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him. So basically that means the defendant needs to understand the proceedings and the gist of what's going on, and then also be able to work with their lawyer in their defense. It is a constitutional requirement to be competent to stand trial, and a criminal case cannot be adjudicated without this requirement being met. And pretty much anybody can raise concerns about competency. It could be the judge, prosecutor, or the defense attorney. And at the point that this concern is raised, then the defendant would undergo an evaluation by a forensic evaluator to determine whether or not they are competent. However, the decision is ultimately the court's decision. So as a psychiatrist, you may be the one doing the evaluation. You will give your opinion on whether or not you think the defendant is competent. You will submit that to the court. The court takes it into consideration, but they could agree with you or they could decide against your opinion. So some of the causes of incompetence, as far as like psychiatric diagnoses go, psychoses and intellectual impairments are the most commonly associated with incompetence. Personality disorders themselves typically are not sufficient to result in incompetence. And amnesia itself also does not typically result in incompetence. So how do we determine competency? So if you're going to say someone is incompetent, you have to have evidence to say that there is a severe disturbance that results in the defendant being unable to rationally assist the attorney or to comprehend the nature of the proceedings and their potential outcome. So this mirrors, of course, the definition of competency, but in this case, it's more of an or statement instead of an and statement. So they could have deficits in being able to rationally understand or deficits in the comprehension, and either deficits in either side of this could result in a determination of incompetence. Historically, these were done by mental health professionals in state hospitals. And so these people weren't trained to do that. They were trained to do traditional psychiatric evaluations. So they essentially were doing a mental status exam, which means most people that had an abnormality on their mental status exam, they would just say that they were incompetent. As we've grown and progressed in the system, we've had more like standardized evaluations and approaches to this. We've had more standardized education of evaluators. And so we now know that just simply having abnormalities on the mental status exam does not mean they're incompetent. So someone that has psychosis, it doesn't mean they're automatically incompetent. You have to look at how that psychosis applies to those two arms of being able to rationally assist and understand the proceedings. And what you would look at if you're going to assess competency on a defendant, of course, you're going to look at the current functional abilities because the competency is about how they're functioning at this moment in time. You might ask things to get an understanding of how much they know about their charges, potential verdicts, and potential consequences, their understanding of the trial participants and the process of the trial, their ability to assist their counsel. So this could be, if they're going to be cooperative with the counsel, if they trust the counsel or have any, paranoid delusions or things like that about the counsel that might get in the way of that, their decision-making ability. So you want to assess if they can make rational decisions. It doesn't mean it has to be, in your opinion, a good decision, but they just have to have some level of rationality to how they arrive at their decisions. And then you can also, so some defendants, the first two parts there with understanding the charges and the trial process, some may just not know that because they just don't have that knowledge or exposure. And so you can educate them in that case and then go back and see, were they able to retain that information? And then are they able to rationally apply that to their case? You can do psychological testing as well. This is most helpful for diagnostic clarity, for situations where there's concern for a cognitive disability. So you can see how severe is that disability, where are the impairments, and then also for malingering. And so there's a list of some of the tests that might be used. I think IQ testing and the MMPI are the two that we're probably all most familiar with, but there are several that can be used. So when someone is found incompetent, they get ordered to restoration. And restoration is focused on, just like it sounds, restoring somebody to competency so that they can then return to their court proceedings. And the restoration is really focused on symptom management. So that might be with medications, for example, plus the legal education. So kind of supporting those arms of the competency definition. Most places, restoration is done on an inpatient basis. Some places are starting to adopt some community-based restoration for defendants where it would be appropriate, but it still remains the majority inpatient. You can do an involuntary medication administration, but it is under relatively limited circumstances. And oftentimes after a defendant goes through restoration, their case ends up being dismissed or they're released on time served. What restoration does not do, it's not a substitute for mental illness or substance use treatment. It doesn't create a full comprehensive treatment plan like traditional mental health treatment would, and it does not ensure long-term improved outcomes regarding their mental illness. The majority of defendants are restorable. About 80 to 90% do eventually get restored to competency. Most of these are within 180 days, and the majority of that is really closer to about 2 months. The people that tend to take the longest to be restored are those with developmental disabilities and long-standing psychotic disorders that have a history of extended periods of hospitalization. And those that are less likely to be able to be restored tend to be older, have an extensive history of mental illness, have prior incidences of incompetence, and have psychotic diagnoses, particularly schizophrenia, or an intellectual impairment, or both. And the combination of an intellectual impairment plus a psychotic disorder has the lowest probability of being restored. And here is a sort of simplified graphic of the process. So we talked about what competence is and what restoration is. So I just wanted to show how the process moves along. So you can see starting on the left, somebody raises concern about competence to stand trial. And like I said, that can be prosecutor, judge, defense attorney, and then they get ordered to have the exam. From there, you can go into arms. If they are determined to be competent by the court, then they'll continue with their criminal process. If they're determined to be incompetent, then they'll be ordered for the restoration. And then from there, they have sort of 2 arms again. If they're restored, then they circle back to the criminal process. So a determination of incompetency doesn't eliminate the criminal process from happening. It just delays it until after the defendant is restored to competency. And then some people are not restored. So if they're not restored, one of the things that could happen is the state could then move to a civil commitment for that defendant. And this is the non-criminal legal process in which someone is involuntarily committed to mental health treatment. So this is more of the type of commitment that we in the community are familiar with. In the standards to meet it, so the level of assurance that the patient meets a criteria for a civil commitment, you have to be more sure that they meet that criteria than you do when you're making a competency determination. And one potential concern is that some communities, so every jurisdiction has different statutes on what is required to meet the criteria for a civil commitment. And so in some places it's harder to civilly commit patients than it is in others. And so there's some concern that in the places where it's harder to do that, there might be an increased reliance on the competency system for quote unquote mental health treatment, which as we discussed just recently isn't really truly a substitute for real mental health treatment. So whenever you talk about competency, I think it's always important to juxtapose that to criminal responsibility. That's not really going to be the focus of what we talk about today, but I think it's important to make that distinction. So like we said, competence is about the defendant's present mental capabilities. Insanity or criminal responsibility is about the defendant's mental state at the time that the alleged offense took place. So these are two independent issues, two separate evaluations, two separate rulings, and they don't necessarily correlate. So if someone is competent, that doesn't mean that they can't pursue an insanity defense. And someone that is incompetent doesn't mean that they were insane at the time that they committed the crime that they're accused of. And just as sort of an interesting example of someone that did use the insanity defense, this is John Hinckley Jr. So he is the man that attempted to assassinate President Ronald Reagan. He did this in an effort to impress the actress Jodie Foster after becoming obsessed with the movie Taxi Driver. So some of his diagnoses included narcissistic personality disorder, schizoid, major depression, and psychosis. And so he, during his trial, pursued an insanity defense, and he was ultimately found not guilty by reason of insanity. And he spent about 3 decades in institutionalized psychiatric care. And September of 2016, he got released out of the institutionalized care on several conditions. And throughout the years, those conditions were gradually loosened. And as of June of this year, he is actually now released without any conditions. And then to compare a competency case that some of you may be familiar with, this is Joseph Oberhansley. So this is a man who is from Jeffersonville, Indiana, just across the river from us here. He was charged with murder of his ex-girlfriend and eating parts of her body in 2014. He had diagnosis of psychosis and a history of a TBI. So during his process, the question of competency was raised. And in the pretrial phase, he was deemed to be incompetent. So he did go through the Indiana state mental health system, went through restoration, and then, like we talked about with the process, returned back to his court proceedings. He chose to reject pursuing an insanity defense, and he is now currently serving life without parole. So we talked a little bit about what is competency and some of the related topics. Now I want to touch on the history. Where did this standard of being competent to stand trial come from? So basically, since the beginning of time, it seems that there has been some sort of allowance for people with psychiatric illness to have an alternative route in the judicial system. So back to English common law, there was an allowance for an arraignment, trial, judgment, or execution of an alleged capital offender to be stayed if he or she became absolutely mad. In 17th century England, they had, so if someone was going to court and they were mute, they were choosing not to talk, choosing not to enter a plea, then the court would determine, are they mute by malice, which is essentially by choice voluntarily, or are they mute by visitation from God, which in our day and age means a psychiatric illness, and they just weren't able to communicate. And so then what the courts would do is if they thought that the defendant was mute by malice, they would sequentially put heavier and heavier weights on top of the chest of the defendant until he was forced to speak. Or in some cases, they did not speak and they ended up dying. And there was no standard method for the assessment of competency prior to about 1960. So we can't really talk about competency to stand trial without bringing up 14th Amendment rights. We're going to talk about a few cases coming up that you will see a common theme, that they violated 14th Amendment rights, because that's really where the standard for competency came from. And the first important clause within the 14th Amendment is the due process clause, which states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." And the second clause relevant to the competency system is the equal protection clause. So this says, "Nor deny to any person within its jurisdiction the equal protection of the laws." And so, like I said, we're going to talk now a couple different cases where this 14th Amendment comes up. And one thing I want to say about the cases is, so I'm going to present them, and the cases first go through a trial court like all criminal proceedings do, but usually then they get appealed, and the cases we're going to talk about progressed up to the Supreme Court, and that's where they made these rulings that now affect how we think about competency and how we pursue evaluating competency today. So the first case is Dusky v. United States from 1960. So this was a man that was charged with rape and unlawful transport of a young female. He was diagnosed with a schizophrenic reaction. He was determined to be competent and was convicted of his charges. And the determination of competency pretty much just came from the fact that he was oriented and he could recall some events of the crime. So when this was appealed through the Supreme Court, the importance of this case was that it established the current legal standard for determining competency. The Supreme Court ruled that just simply saying that he was oriented and could recall some events, that didn't meet the criteria. That's not good enough to say that someone is competent to stand trial. And so their ruling of what is competency is a sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. So that sounds almost word for word of the definition I gave you earlier. And that's because this, what we call Dusky standard, is still the standard we use to this day to make a competency assessment. One thing it did not do, though, was it did not address what conditions could lead to incompetency or how to manage an incompetent defendant. The next case is Pate v. Robinson from 1966. So this was a man charged with murder of his common law wife. 2 to 3 months pre-trial, he was determined to be competent. And then during trial, his lawyer raised some concerns because he was hearing voices, hallucinating, and had pronounced irrational behavior. However, the trial court refused to allow another competency assessment. So when this moved up in the appeals process, the Supreme Court ruled, again, this was a violation of his 14th Amendment rights by not allowing another competency assessment when the lawyer raised concerns. And what they stated was that the due process clause of the 14th Amendment requires trial courts to hold a suitable hearing on competence to stand trial whenever there is a bona fide doubt about a defendant's competence. So basically, this case established that it's a relatively low threshold for holding a competence hearing. If anyone in the court process has concerns, then to meet the 14th Amendment rights, we need to pursue a competency evaluation. Wilson v. United States. This is a case from 1968. So this was a man who, with an accomplice, stole a car and held up a pharmacy. The police then pursued them in a high-speed chase. During the chase, their vehicle left the road and they ended up crashing into a tree. In the process of the crash, his accomplice died. He suffered a head injury, which resulted in retrograde amnesia. So he couldn't remember anything pretty much from the afternoon of the day of the crime and up until he woke up, which was about 3 weeks later in the hospital. His mental condition, though, was otherwise considered to be normal. So during his initial trial, he was found to be competent. He ultimately appealed this decision, saying that he was not competent to stand trial when they went through the trial process because he had amnesia. So when this case moved up to went to the DC Circuit Court of Appeals, they determined that amnesia does not automatically mean that someone is incompetent, particularly when the knowledge of events can be reconstructed and the defendant can follow the proceedings and discuss them with his attorney. So they came out with sort of these 6 different factors to use when assessing whether or not amnesia did result in incompetence in a case. And it pretty much just goes straight back to that definition of what competency is, looking at how did the amnesia affect his ability to work with his counsel, how did it affect his rational decision making, how did it affect his understanding of the court process, and things like that. So as you can see, just having amnesia of the crime doesn't necessarily mean that he would not be able to do those things anymore. And the next case we're going to talk about is Jackson v. Indiana. This is from 1972. So this case was a male in his 20s that was charged with 2 robberies that had a total combined value of $9. At the time, they described him as mentally defective, deaf mute with a mental level of a preschool child. So as you can guess, he was determined to be incompetent. He was also determined to be unlikely to attain competency in the future. So what happened with his initial trial was that he was then committed to the Indiana mental health system until he could be deemed sane, which in this case, sane isn't necessarily the right word because we're not talking about insanity. Really, they meant competent. And his lawyer appealed this, saying that, well, this is a violation of his rights because he's not going to attain competency. So this is effectively giving him a life sentence. So when this case moved up to the Supreme Court, they agreed and they said that committing him until he was determined to be competent, which was unlikely to happen, was violating his 14th Amendment rights. And they said that due process requires that the nature and duration of commitment bear some reasonable relation to the purpose for which the individual is committed. And in addition, if it is determined that a defendant will not attain competency in the foreseeable future, then the state needs to either pursue the civil proceedings that we talked about earlier, or they need to release the defendant. So this case is important in that it was the first time that a standard was set saying that defendants can't be held for extended periods of time for competency evaluation and or restoration. Prior to this, many states sort of just kept these types of patients indefinitely. It did not, however, address what length of time is considered reasonable or how to monitor the progress towards regaining competency. So now we talked about what competency is, what's the history, where did it come from? And now I want to talk about what's the current state of the competency system. So looking at some numbers, 8 to 15% of felony defendants are referred for an evaluation. About half of the people referred for evaluations are charged with misdemeanors. 20% of evaluees are ultimately found incompetent. And at any point, there's about 4,000 defendants in the US that are currently hospitalized for restoration. And so here's a chart looking at how long it takes to reach restoration. This is from data from a Washington State hospital. So for the felony defendants, you can see the average time to restoration is around about 9 months. And for the non-felony defendants, 90 days, 3 months. For the non-felony defendants, it's about 1 month. So it's pretty significant difference for length of time to restoration when split up by those level of charges. If we look at the population of the forensic patients that are in state hospitals, so these are the people that are undergoing restoration currently, 80% have a psychotic condition, 15% have a mood disorder, 10% have a substance use disorder as their primary diagnosis, nearly 50% have been homeless in the previous year, and 45% had 15 or more prior arrests. And here is a study that was done in California and looked at these defendants who were in the restoration process and what did their mental health care look like 6 months prior to their arrest. They found that 47% had received no billable mental health services at all. 23% had received 1 to 2 mental health services in an emergency department. 20% had received 3 or more mental health services in an emergency department, and 10% had received no mental health emergency department services. So the demand, when we're talking about the current state of the competency system, demand is where really we have to focus on, because there has been a very significant increase in the demand for evaluations. In 1973, there were 25,000 evaluations done in the United States. In 2000, that increased to 60,000. And in 2019, that increased to over 91,000 evaluations per year. From 1999 to 2014, there was a 74% increase in the number of forensic patients in state hospitals and a 72% increase in the number of incompetent to stand trial patients. So we're not only seeing an increase in the amount of evaluations being done, but we're also seeing an increase in the number of people that need to be restored to competency. A nationwide survey was done. So this was asking people that run these forensic state departments about the environment of the competency system in their state. 68.8% had an increased rate of referrals for restoration for misdemeanors. 65.3% had an increased rate of referrals for felonies. 78% had an increased rate of referrals for both felonies and misdemeanors. And 70.8% had a wait list for admitting incompetent patients for restoration. And 38.8% stated that their state was currently facing a litigation related to issues with the admission of incompetent patients into their system of care. So these numbers are pretty significant to show most places are experiencing a big increase in the demand and are having a hard time meeting that demand. Here is a chart from Washington State showing how their demand for evaluations has increased. So if you look at that top black line, that's the total amount of orders. The lines below that are just the break it down in the different types of orders. But you can see in 2013, they had about 3,000. And in 2021, so only 8 years later, it had doubled up to 6,100. This was from a survey with all of the different states. It's a little difficult to look at on the screen, but if you look at the right side, the red bars, so each bar is a category of dates, and it shows you that from the first bar, 1999 to 2005, and then moving to the last bar, which is 1999 to 2014, how much that has increased. Pretty significant. And then here they were looking at the census for the number of adult forensic patients in the state hospitals. And so in 1999, if you look at the average for the red line on the top, there's about 350 average per state. And then in 2014, that increased up to over 500. So this shows the increase in the number of incompetent patients that are undergoing restoration. Interestingly, the blue line, the median, actually stays relatively flat. So that could suggest that there's some states that are outliers that had either really big or really increases or decreases in their census. So when we have this increased demand, we're not meeting the demand. What does this cost to the defendants themselves? One of the big things is that their wait times are obviously much longer. And at some points, their wait times for evaluation and or restoration has exceeded the time that they would have served if they had been convicted of the alleged crime. Jails are pretty destabilizing for people with mental health needs. They're isolated, they're separated from community-based supports and treatment providers, potentially exposed to trauma. Medication regimens are often changed because jails have pretty limited availability. Non-pharmacologic mental health care is quite limited in those settings. And then after they're restored, they go back to jail to wait continuing their court process. And so again, being back in this destabilizing setting, this runs a risk of creating a cycle where someone is restored, they go back to jail, destabilize, they're incompetent again, so then they have to go back and get restored again, and they just kind of cycle through this process. Oftentimes when the defendants are released after this process, they re-enter the community without access to mental health treatment, without a robust and defined treatment plan. And so all of this is to really just reiterate that restoration is not a substitute for mental health treatment. And the defendants aren't the only one that are having significant costs with these delays. So for everybody else, the cost to house those with mental health needs or intellectual disabilities in jails and state hospitals is actually a lot greater than the cost it would be to provide them with community-based treatments and housing. Civil beds are being converted into forensic beds to try and meet this demand, but that means we're losing civil beds. So that's further impairing things on the general civil mental health side of things. States are facing fines and lawsuits because of these 14th Amendment right violations. And it's a delayed process. So pretty much like any industry, anything that's delayed, you're doing things for a longer period of time, typically has increased financial costs. Looking at the money specifically, we don't really know how much they cost, but a quoted number that I found was approximately $5,000 per competency evaluation. And back in 1985, they estimated that we were spending $185 million per year on competency evaluations and treatment. So with the increase in demand plus inflation, this cost is likely at least 2 to 3 times that now. And here's a quote from a judge that presided over one of these cases. She said, "It has cost us more than $3,000 to try to restore competency to a young woman on my docket. And yet when her charges are dismissed, she will have no housing and no community supports or services. The community and this young woman would have been far better off if we diverted her out of the criminal justice system at the beginning and invested the money spent on restoration, on services and housing that would support her for the long run." So I thought this quote was just very appropriate to sum up all of those costs we were talking about. Trueblood v. Washington State Department of Social and Health Services. This is a class action lawsuit from 2015 that challenged these unconstitutional delays in the competency evaluation and restoration services for people in Washington state jails. At the time, they were being held for about 29 days waiting for these services. And as we'll shortly get to, you'll realize 29 days actually isn't that long compared to several other states. And the court ruled that this was untimely, and by not providing these services in a timely manner, they were violating the due process clause of the 14th Amendment. The state was ordered to provide their evaluations within 14 days and restoration services within 7 days of a court order. The state, of course, had trouble meeting this demand and ultimately ended up accruing over $100 million in fines for contempt of this order. And so I bring up this case to show, first off, the financial and legal consequences for the states of not adequately meeting this demand and violating these due process rights. But also, Washington state is not the only state undergoing these issues. Several other states in the country either are currently in litigation or have gone through litigation over issues related to these delays in competency services. And here is something that the judge in the Trueblood case said. He said, "Our jails are not suitable places for the mentally ill to be warehoused while they wait for services. Jails are not hospitals, they are not designed as therapeutic environments, and they are not equipped to manage mental illness or keep those with mental illness from being victimized by the general population of inmates. Punitive settings in isolation for 23 hours each day exacerbate mental illness and increase the likelihood that the individual will never recover." So now I wanted to show some relevant stories from the media. So this isn't something that's just hidden in our forensic population. It's become something that the general public is aware of because they have seen the effects that these delays have on people. So this one is from the Atlantic in 2019, and they talked about this case of this male 26-year-old. He was initially charged with stealing a hamburger and fries. At the restaurant, he was acting irrational, believed streetlights had cameras in them, and they determined he needed to go to the hospital. And while the paramedic was trying to get his blood pressure, he was very paranoid and punched the paramedic. And so he continued to the hospital. His diagnoses were psychosis, probably a bipolar disorder, and the charges for the stealing were dropped. But when you assault an emergency medical provider, that's a felony. So he was then brought into the court system on the felony assault, and he was deemed incompetent. He was placed in an out of custody program, so like a community-based program. However, the program hadn't actually been set up yet. So he wasn't really actually receiving any services. And while he was out in this program that wasn't there, he had made some Facebook posts that the judge took as threatening towards the paramedic. So then the judge ordered that he needed to have an inpatient restoration. There wasn't a bed available, so he was sent to jail to wait for a bed. He waited 55 days in jail for his restoration bed, and reportedly was without psychiatric treatment during that time. Here's one from New York. A man was arrested in 1986 after allegedly shooting 3 people in broad daylight. The police report said he was incoherent, seemed to be on drugs. He was diagnosed with schizophrenia. So he had his first evaluation ordered in January of 1987. And since then, 8 judges have ordered at least 31 evaluations on him. He's been committed to psychiatric facilities at least 29 times by judges. He or his attorney have appeared in court greater than 236 times. And so over this course of 30 years, he has been cycling between the jail and state hospitals without ever actually getting through his trial. In Ramsey County, Minnesota, they recently came out with this article just a little over a month ago, and they were reporting they have people sleeping on mattresses on plastic cots in their jail because they have such a bed shortage, and they attribute this shortage largely to the increase in mental health evaluations. Their average stay currently is about 72 days for a defendant awaiting an evaluation, and their CST referrals have increased by 84% from 2020 to 2021. So you can imagine that's a pretty steep increase to try to keep up with. And in Minnehaha County, South Dakota, this is from 2015. So in fiscal year of 2015, they had 147 requests for evaluations, but their state hospital will only conduct 36 per year. Their average wait time is about 4 months for an evaluation. And last year, so when this was written would have been, I think probably 2014 data, they had spent $100,000 on evaluations by private psychiatrists because their state system could not keep up with the demand. And so they had a few cases that they had expressed from their county. So 72-year-old male diagnosed with schizophrenia. His neighbors called for help after hearing banging and other bizarre noises. The defendant answered the door with a knife and was refusing to leave. He waited in jail 8 months for his evaluation. A 21-year-old male was arrested in April of 2014, allegedly had broken into an apartment to steal $40 in medication. He waited 11 months for his competency hearing. At the time that the article was written, his case was still unresolved. A 33-year-old male arrested in January of 2014 for allegedly trespassing, possession of meth, and resisting arrest. He waited 11 months for his evaluation and subsequently was committed for restoration. 38-year-old male diagnosed with schizophrenia. He was charged with assault of a police officer during a quoted schizophrenic episode. He spent 8 months in jail. 5 of those months were waiting for an evaluation, and he ultimately pled guilty to his charges. So I talk about all of those just to show how prevalent this problem is. Here are just news article title excerpts that are from all across the United States. And most of them are relatively recent articles. All you have to do is a Google search and you can very quickly find numerous articles about this issue. So to reiterate the problem, there's increasing demand for CST evaluations, and we're not able to meet those demands right now. This has resulted in delays in people being evaluated and restored. And we can't go without saying the COVID pandemic the last few years certainly made those delays much worse. These delays have resulted in significant costs to people involved in the process and the general public. And some of those, just to review, are extended wait times, due process violations, worsening of behavioral health needs, and significant financial costs. So what are some ways that we can approach this problem? Starting off, there was this survey, the one that surveyed the state forensic health systems, and they asked them, what do you think is the most impactful reason that we're having this problem right now? The number one answer was inadequate general mental health services. The next was inadequate crisis services in the community. Inadequate number of inpatient psychiatric beds in the community. And inadequate ACT services in the community. So yes, there's probably some fundamental issues within the competency system itself, but as you can see, people in the system that are dealing with this crisis on a daily basis really attribute a lot of the issues to our general mental health system and issues that we're having in cracks that people can fall through. So some proposed solutions are to increase the threshold for pursuing the competency evaluation and restoration process to more serious charges that would be more worthwhile, a stronger interest in pursuing for the state. And so with this, you would dismiss lower charges or send them to a diversion program that would then focus on getting them the mental help they need. Also, to use the least restrictive environment. So with restoration, if you can do community-based restoration, if that's appropriate for that defendant, use that. So then we can free up some of the inpatient beds. And one of the big ones is just focusing on preventing criminal justice involvement in the first place. So establishing a robust system of community treatments and supports, and really paying attention to the structural factors with this. So things like access to housing and access to transportation that can have significant impacts on a patient's ability to access psychiatric care. And then if someone does go through the restoration process, pairing that evaluation with a robust treatment plan. So trying to make the treatment plans as close to a true full mental health treatment as possible. So at least if they're going through this process, maybe they will have some improved long-term outcomes. In this, I just wanted to touch on, this is the Justin Well report. It's from October of 2020. This was the result of a meeting of several national leaders because this competency system has become such a problem. So they met to talk about the overburdened system and how can we fix this? How can we help reduce these delays? And they came out with these 10 strategies to approach the problem. I won't read all of them, but essentially, if you look at those, it goes in line with the solutions we just talked about. And here's an example of trying to implement one of those solutions, the Miami-Dade Forensic Alternative Center program. So this program diverts people charged with second and third degree felonies from traditional state restoration facilities to a local inpatient hospital. While they're there, they get the restoration services, crisis stabilization, they develop community living skills, they assist with community reentry. So thinking about things like housing, employment if it's appropriate, being set up for benefits. And then there's community monitoring to ensure that the defendant is getting ongoing follow-up after their discharge from the program. And so this program, the courts monitored them for at least 1 year following completion of the inpatient part of the program. And most people had their charges dismissed upon successful completion of the program. So in doing this, they monitored the defendants and their progress and found that discharge from their inpatient forensic commitment happened 73 days or 33% sooner than the people that had gone through the traditional state restoration facilities. The defendants were half as likely to return to jail during the year following reentry and spent 41 fewer days in jail in that year following reentry than the people who went through the state forensic facility. And the cost to this local facility was half the cost of admission to a traditional state forensic facility. So those are pretty promising results for this sort of intervention to try and reduce the burden for the state forensic facilities in particular. So it's pretty easy to come up with ideas and suggestions, but there's definitely some challenges to actually implementing those. The biggest thing is that each individual state differs. So like I was saying with the civil commitments earlier, each jurisdiction has their own statutes and ways of going about things. And so it's hard to, come up with a plan for improvement if we don't know how all these systems work, and we don't know how they all work. And so without this lack of data, we really can't be making adequate policy changes because we don't know how it's going to impact each of these different systems. It's not like a blanket suggestion will apply everywhere. So this brings me, I want to introduce a little bit the project I'm working on with Dr. Hackman, as well as Will Schroeder, who's an attorney in the community. And our project is a survey of competency to stand trial evaluation systems in the US. So just slightly more background with these differing state systems, you can have private evaluators or evaluators that are employed with the government. And then they also differ in how evaluations are paid for. So some states operate under a free market system where an increased demand leads to an increased price for an evaluation, and then it becomes more desirable for evaluators to complete. Others operate under a set price. So with this, the demand can very quickly outpace the supply of evaluators that are willing to do the evaluations if the price is set too low. Telehealth, we're all pretty familiar with at this point. There's been significant increased use and acceptance in recent years. And for us, we think it's potentially a very useful tool to enhance the availability and the efficiency of forensic evaluators. And then there's these things called interstate compacts. So these are essentially licensing agreements between states. And there's two that is applicable to what we're looking at with making changes in this competency system. The first on the left there is the Psychology Interjurisdictional Compact. This is for psychologists and essentially gives licensing reciprocity across state lines for the states that are part of the compact. And then the Interstate Medical Licensure Compact is for physicians, which the physician still has to have individual state licenses, but it provides a cohesive application. So it really streamlines the process to get that multi-state licensure instead of doing a different application for every single state. And as you can see, the blue states are the ones that do participate in the compacts. So there is a good number of states that do participate. And when you use this in combination with telehealth, it really can exponentially increase the reach of even just one single forensic evaluator. So our hypothesis is that one of the solutions to help these delays in the CST process would be to remove barriers between evaluators and those that are needing evaluations completed. And this could be done through the use of technology with telehealth evaluations, as well as a connection enhancing website where people that need evaluations can seek out people that are willing to do the evaluations, even across state lines. What we're doing is telephone interviews using a semi-structured survey format. We started with people that we knew directly in the forensic system, and we're getting further participants through a snowball sampling method where we, after interviewing someone, ask for references to people that they think would be able to answer the questions that we're asking. And our goal is to obtain a minimum of 2 knowledgeable study participants for each state and the District of Columbia. We'll primarily be gathering descriptive data, and we'll categorize that data on 2 main sort of categories: the amenability for private forensic evaluators in that state, and then the state's openness to having tele-evaluations completed. So currently, we've contacted a few different states, so you can see there, but we've only been able to interview Kentucky so far. So we just got our final IRB approval this summer. The process took a little while, so that's where we're at. But we have several states that we're reaching out to, and hopefully the list of interviewed will quickly grow. So Kentucky, what does Kentucky look like? The statutes are currently written to require inpatient evaluations. However, some jurisdictions have been allowing orders with flexible terms where they can allow in jail or outpatient evaluation. For felony defendants, it was exclusively inpatient until March of this year. The wait list for an inpatient request is 10 to 12 months to get in, and then for a flexible order, typically they can be done within about 2 weeks. For to be an evaluator in Kentucky, you have to have an affiliation with KCPC, so that's our state forensic hospital just outside of Louisville here, and you have to be either a direct state employee or you can be contracted with the state through something called a request for proposal. And just recently, Kentucky started to allow telehealth evaluations. So what does this mean for private evaluators in the state of Kentucky? Some positives are that telehealth is available. It's a member of both of those interstate compacts. There's a really long wait list, so there's a lot of work available for evaluators, and there's no special certification required. Some possible negatives might be that the court orders, not that many, are quite flexible yet to allow for the telehealth evaluations and or the outpatient evaluations. The cost is at a set price of $900 per evaluation, and there's no adjustment with demand. And it may take a little bit of time to set up that contract as with the state as a private evaluator. So our assessment of the current market in Kentucky is that it's a high opportunity market. However, not quite yet. The state needs to incorporate and adopt more of those outpatient and telehealth evaluations before we could really pursue it as a high opportunity market for us. Indiana, we haven't interviewed, but our team has some personal experience working in Indiana. So from that experience, we know that telehealth is available. They are a member of the psychology compact, but not the physicians compact. There's a high demand for evaluators, particularly in rural communities. No special certifications are required. The cost for evaluations is pretty flexible and tends to be based on the time spent on the evaluation in many of the counties. And it doesn't take very much time to set up a contract as a private evaluator. The biggest potential con in Indiana is that judges don't really know how to contact new evaluators. They typically just rely on people they've used before and sometimes word of mouth. And they may be unwilling to have the telehealth evaluations done. So our assessment of the market is that it's high opportunity, and that's an accurate reflection of the current state of the market. Tennessee, we have a little bit of information on from literature. Positives are that they prefer outpatient evaluations, telehealth is available, and they're a member of both of the interstate compacts. Potential con is that they do require a special forensic certification that is awarded through the state of Tennessee itself. So our assessment, it seems like it could be potentially a high opportunity market for private evaluators, and that probably reflects the current market. But of course, we need to do the interviews to make sure that we have an accurate and full picture of what the market is really like in Tennessee. So why do we think it's important to pursue this research? To get that congregation of the data. Like I was saying, with the states having different systems, and we don't have a comprehensive view of all those different state systems. And so this can then help us to understand the systems And from there is when we can really start to make systems development, create effective ways to improve the competency system. And then ideally, this will reduce costs, hopefully for everybody involved in the process, but at least for some. So in conclusion, competency is evaluated based on the task at hand at that moment in time. Competency to stand trial is grounded in our amendment rights. There's been a significant increase in demand for competency evaluation and restoration, which has resulted in delays for these services. These delays have resulted in due process violations with costs to those directly involved in the process, the defendants, and to the general public. CST systems and standards differ state by state, and we don't have a comprehensive understanding of those different systems. And we need to increase our understanding of those systems so that we can develop effective improvements and reduce these costs that we're currently experiencing. These are my resources. And any questions or comments?
Great, excellent job, Lexi. Thank you so much for giving that presentation. It was really, really interesting, and it was very interesting hearing more of your interest as you kind of continued into learning more about forensics and making that your specialty of choice. So I'm going to start admitting people to be panelists. Saber is also doing that. So if you have any questions, raise your hand and we will promote you.
Okay, hello. Thanks for the presentation. It was great. Very thorough, very full of information, and the presentation followed. I really like the way you followed it, and I could follow it and really feel like I have a better understanding of the situation. So very good job. Thank you for that and for educating me on that. I'll ask, so what's the explanation? I mean, I could come up with a bunch of ideas, but what's the explanation for why they doubled in such a short amount of time? I mean, we've had a mental health crisis for quite some time now. There's no doubt about that. But any thoughts about why, when you presented that, why it changed so quickly? That's it. Thank you again.
Yeah, I think that's a really good question that I don't have a perfect answer for. I think there's a lot of things, like you said, just ongoing mental health crisis. I think increased also recognition and understanding of mental health in the general public. And so more people within the legal system might be recognizing that people are suffering from a mental illness. And then I think also that factor of, like I was saying, with some areas, it can be hard to civilly commit people. And so when you have like those with severe mental illness that don't want to get help, and then they just don't really have a solution, so they commit the crime, and then there's increased use of the competency systems because they just don't feel like they have an alternative.
Hey, Lexi, this is Megan Good. Thank you so much for the presentation. This was excellent. I had a quick question about a different type of evaluation. I know the Daryl Brooks case has been in the news recently, who, for those who don't know, is the gentleman who drove through the parade in Waukesha. He was deemed able to perform as his own counsel. And I'm wondering what an evaluation for that would look like, because obviously acting as your own counsel is a very specific skill set. And is that something a psychiatrist would determine? Could you weigh in on that?
Yeah, so it still is something that like a forensic psychiatrist or forensic evaluator would participate in assessing their competency to be able to do that. And overall, any type of competency still stems from that Dusky standard, but I do know that there has been some cases, some actually pretty relevant cases in the forensic community where this exact instance happened, that they simply were considered competent by this Dusky standard, and they said, well, they're competent to stand trial. So then they went to represent themselves, and at court, they were very clearly symptomatic. And so there was some rulings out of that that makes the evaluation for representing yourself a little bit more, I don't know if stringent is the right word. They have to have a higher level of competency to be able to do that than just say that they can stand trial, if that makes sense. I don't know exact details because I've never done one of those, obviously. So I don't know the exact details of like what sort of characteristics you have to look at when considering their ability to represent themselves.
Thank you so much.
Hey, thank you for that wonderful presentation. A lot of relevant information for us to be knowledgeable about. The data you presented, it in a way makes a pretty strong argument for need of institutional facilities. And just kind of to pick your brain, what do you think the data would look like, or the current picture would look like if that, the Community Mental Health Act of 1963 had still been around?
Yeah, I think that's a very interesting thing to point out, and I suspect it probably would look a little bit different. Obviously you can see the arguments both ways, kind of like going back to that Wilson case where he was essentially going to be, committed for life because he wasn't going to be restored to competence. And you can see how when you're thinking about personal rights, it doesn't really seem appropriate to keep people long-term institutionalized. But we also could balance that with more of these sort of community types of institutionalization where, yeah, they're institutionalized and getting this treatment, but they still have some of those community freedoms that they wouldn't in these more forensic type of settings.
Absolutely. Thank you.
Hey, Alexi, thank you for the excellent presentation. I really enjoyed it. I guess that Syed may have touched upon it, but since you are doing this study to try to gather the data so that we can speed up and sort of kind of put the resources in the right places, I'm wondering, once you do that, is the restoration going to be a big bottleneck once you have done that? Once people are adequately evaluated, are there beds for people to be actually treated? I guess you sort of talk about community, but don't we have to do both at the same time? And I also wonder, what is the current bottleneck in Kentucky right now? Is it the evaluation or is it the beds?
Yes, so absolutely, we need to have solutions for both. So, only when you have the evaluations, only 20% are typically found incompetent. And so it's not like every person that has an evaluation will need the restoration services, but we also have a lot less restoration beds available than we do, spots to have evaluations done. And so our research, will hopefully help move along the evaluation part. But you're absolutely right. There still could be a bottleneck on the restoration part, which there is. And that's part of the reason these people after they wait in jail to get their evaluation for extended periods of time with these like due process violations, but then it's not done from there. Then they wait another extended period of time until a restoration bed fills up. So there are two sort of stopping points in this process right now. So absolutely. I don't remember. What was your second part of the question or the last part?
I was just wondering what's a bigger bottleneck in Kentucky, but I guess you sort of answered that 80% of the people actually don't need restoration. So I guess that makes sense.
Yeah, and one of the things with Kentucky too is that so we had KCPC is our like state forensic facility. And the way those orders are written with the inpatient evaluations, that means someone has to go to KCPC, stay there for some period of time just to have the competency evaluated. That's not restoration. And so that really creates a huge bottleneck in terms of both getting a bed for an evaluation plus a bed for restoration. And that's why more and more communities across the United States are starting to allow the outpatient evaluations. And I think that's also part of the reason why Kentucky is sort of off-label, allowing these flexible orders to help move things along.
Thank you.
Do have another question. I wanted your opinion, and I think many of us are familiar with this. You're overnight in EPS or in during the daytime, and you get a patient from the prosecutor's office with a huge packet of competency evaluation that has been dismissed, without prejudice. Charges have been dropped, they're incompetent. And what do you think we could be doing in EPS at that stage where the patient has had the full evaluation to help that patient more? What do you think?
That is a good question. I don't know. I think part of it too is like we will get in EPS or even on the units, you get these records that patients have been incompetent, and sometimes it's kind of like, well, what do we necessarily do with that information? And I think part of presenting on what competency is was to highlight that it's at that time, at that moment for that task. So while some of the information in the evaluations is certainly relevant to us, and it's nice to know that they've been incompetent in the past, it doesn't always necessarily help us in that moment in making a decision. Are they currently mentally ill? Are they currently, fit to be in the community, or do we need to civilly commit them? And so I think just sort of remembering that distinction, that doesn't necessarily impact how we choose to treat them. We still, when they come into EPS, are going to do what we would normally do with our evaluations and choosing what treatment is best for them.
So to follow up on that, if a patient comes into EPS incompetent to stand trial, does that mean they are incompetent, but the judge chose not to restore it? That's why they're there, or instead of a restoration facility, or is it because they're waiting for restoration?
That I don't quite understand, because I don't know what the trail of the process is when like they're deemed incompetent, and then what is the trail that they actually got to us? Because if they were ordered to go to restoration, they wouldn't go through us in EPS. And my understanding would be also, if the court ordered them to a civil commitment at that time, they wouldn't go through EPS, because we're making that decision, right, in EPS, whether or not they need to be committed. So I guess I don't really have a good answer, because I don't quite understand how we get those people sometimes. And if anyone else knows, I'd be happy to hear your opinions on that.
Hey, Alexi, great presentation, by the way. My guess would be that when the judge finds somebody incompetent, then they have to decide whether that person's restorable or not. And in Jefferson County, a lot of times when they're found unrestorable, they will civilly commit But I think the process for that, I'm not sure if that means they go to Central State or if they could go to EPS to begin that process. So that's one possibility. In a lot of other cases, if the charges are minor and they find them unrestorable, I think a lot of times the charges are dropped. And so my guess would be like, you got this person who's incompetent, unrestorable due to mental illness, that we're going to drop the charges. And my guess is maybe they end up in EPS because it's like, well, we got to do something for them. But I don't know for sure what the judges are doing directly, but that'd be my guess.
Thank you.
Hey, Alexi, we have a question in the chat that says, as a future forensic psychiatrist, do you know how many are practicing in the States and how many we need to serve the forensic population?
That I do not know how many are in the state currently. And I think that knowing how many we need to serve the population is a difficult question to really answer. Especially with as the demand continues to increase. I think it's honestly sort of like an exponential number at this point. But I do not know any specific numbers or data on that.
Anybody else has any other questions? Well, thank you, Lexi, so much for a wonderful presentation.
All right. Well, thank you everyone for being here.